Okay, so have you ever felt like the legal world is kind of like a secret society with its own language?
Yeah, it can definitely feel that way.
Well, today we are decoding that language. We're diving into the Pro Se Litigants Civil Litigation Handbook, and I gotta say, it's eye-opening to say the
It
least.
really pulls back the curtain.
It does. So we're going to try to break down some of these intimidating legal concepts into something you can actually use, especially if you're facing a civil lawsuit and you're on your own.
Absolutely, because it's crucial for pro se litigants especially to grasp these concepts.
Yeah, and the handbook doesn't sugarcoat it. One of the first things it says is law is a business.
It is.
So it's really about strategy, knowing how to play the game, especially when you're representing yourself.
Absolutely. Think of it like going into a business negotiation.
Yeah.
You wouldn't just show up empty-handed. You'd come prepared. Figure out your leverage, your bottom line, all of that. This handbook is like that prep work, but for the legal world.
And that's where this whole pro se explosion comes in, right? I mean, the handbook talks about how there are more and more people choosing to represent themselves in court these days. What I found really interesting was how it connects that to what we were just talking about, that business mindset.
Hmm.
Like, it's not just about the cost, although that is a huge factor for a lot of people, but it's also that people are realizing, hey, I might actually have some leverage here, even against a big company or an experienced lawyer,
Yeah,
if they're willing to put in the time to learn the rules, do the research,
right.
and fight for themselves.
That's the key. It's about empowerment through knowledge. People are fed up with the way the system works, and they're realizing that they can take control.
I love that. Okay, so let's say we're in the arena, we're doing our homework. What's the first thing this handbook tells us to expect?
Well, it tackles a big misconception head on. The judge is not your friend. Now, that doesn't mean they're out to get you. They're supposed to be impartial. But the handbook uses this case, the Turner case, to show how pro se litigants can be at a disadvantage in court.
Okay, so this is what I mean about going deeper than just the surface. Tell us more about this Turner case. What happened? Why is it so important for someone who's representing themselves to know about?
So in the Turner case, the judge made a comment that seemed, well, a little biased against the person representing themselves. And the really important thing is that when the case went to appeal, the higher court actually said that the judge should have been more aware of the power imbalance in the situation and done more to make things fair.
So it's almost like they were saying the judge should have bent over backwards a little bit because this person was representing themselves.
Exactly. And this is where all those skills the handbook keeps mentioning, communication, research, emotional resilience, they become crucial.
Okay, I can see how all of those would be important. But give me an example, like how does one of those skills, let's say being really meticulous about documentation, how does that actually help you when you're in court?
Okay, imagine this. You're in a contract dispute, right? And you were super organized, documented every phone call, every email, every single detail leading up to the lawsuit. Now, the other side is claiming you're the one who broke the contract. But because you have all that documentation, you can prove that their version of events just doesn't hold water.
Oh, so it's not just about what happened, but what you can actually prove happened.
Exactly.
And that documentation, all that meticulous record keeping, that's your ammunition.
Precisely. And that meticulous documentation feeds directly into building your legal arguments. That's where understanding torts comes in, and the handbook dives deep into this.
Okay, let's unpack this term. Torts. It sounds a little bit like a fancy dessert or something.
Right.
But in legal terms, what are we talking about?
Basically, a tort is just a civil wrong. It's when someone does something that harms someone else.
Okay.
Think of it this way. Let's say someone rear-ends your car because they were texting and driving. That's negligence.
Okay.
That's a type of tort, and you'd have grounds to sue them because you were harmed by their actions.
So understanding different types of torts is like having different legal arguments you can make. Like, hey, this specific legal wrong happened to me, and because of that, I deserve some kind of compensation.
Exactly. And the handbook even gives examples of some lesser-known torts, like intentional infliction of emotional distress.
Okay, now that one sounds intense. What does that even mean? Give us a real-world example. Like, how could understanding that specific tort actually be a game changer for someone?
Okay, let's say you're dealing with a debt collector who's just relentless. They harass you constantly, even after you've tried to explain your situation. Their behavior is just way over the top, goes way beyond what's considered normal for debt collection. Knowing about this tort, intentional infliction of emotional distress, could give you the legal standing to fight back against that kind of harassment.
Wow. I'm already starting to see how just knowing this stuff, these legal terms and concepts, can really level the playing field, like you were saying.
It absolutely does. But
Yep.
knowing what legal arguments you can make, that's just step one. You then have to find the actual laws, the cases that support those arguments. And that's where legal research comes in.
Right. And let's be honest, for most people, legal research sounds about as fun as a root canal, right? I mean,
Yeah.
where do you even begin?
That's where the handbook's roadmap is so helpful. It breaks down how to use online resources,
Hmm.
how to understand those really dense legal documents. It even explains the idea of precedent, which is so important in law.
Precedent. You mean like, my older brother got away with this, so I should too.
Well, not exactly.
Okay.
In legal terms, precedent means that courts are supposed to follow rulings in similar cases that have already been decided.
Oh, I see.
So if you can find a case similar to yours where the judge ruled in favor of the person in your position, that's huge. It's like finding buried treasure.
Oh, okay. So you're basically building your case based on how the law has already been applied in past situations.
Exactly. You're building your argument brick by brick, and those past cases, those precedents, they become the foundation.
That is fascinating. Okay, so we've got the arguments, we understand the idea of precedent, but we also need to be able to actually present our case. And the handbook doesn't shy away from all those, well, let's face it, often dreaded legal documents that you might have to create.
Right, the paperwork.
Oh, yes, the land of heretofores and party of the first part. Honestly, just thinking about writing a legal document makes my head spin a little.
Yeah,
But the handbook does make it seem much more manageable.
it does. It emphasizes two main things. First, clarity is king. Judges don't have time to wade through a bunch of jargon and confusing sentences.
Right, they want to get to the point.
Exactly. And second, it's about knowing what to include and, just as importantly, what to leave out.
Oh, okay. So give me an example. What's a common mistake that people make when they're drafting these legal documents that could actually end up hurting their case?
Rambling. It's so tempting to include every single detail, every emotion you're feeling, but a good legal document, it's like a laser focused and to the point. The handbook gives examples of what to include in a complaint, a motion, even an affidavit, and it emphasizes keeping it concise and sticking to the facts.
Okay, so we're building our case, we're getting the hang of legal writing, but what about the actual information we need to prove our point? The handbook talks a lot about discovery, which honestly makes me think of buried treasure and pirate maps.
It does have that kind of ring to it, but in a legal context, discovery is all about uncovering information from the other side. Like you're putting a puzzle together and you need those missing pieces.
And the handbook mentions there are different tools you can use during this process. What are some of the main ones we should know about?
Right, well, you've got interrogatories, which are basically written questions you send to the other party, and they have to answer them under oath. Then there are depositions, which are more like in-person interviews, also under oath, where you can dig a little deeper.
So interrogatories are like sending an email, and depositions are more like a face-to-face meeting.
Exactly, and both can be incredibly powerful tools. Let's say you're in a business dispute, and you think the other side might be hiding some crucial financial information. Asking the right questions in interrogatories and depositions could force them to reveal what they're trying to keep under wraps. And that could be what wins your case.
So it's not just about asking questions, it's about knowing which questions to ask and how to phrase them strategically.
Exactly. That's where those sample questions and examples in the handbook are so helpful. They teach you how to get the information you need without revealing too much about your own strategy.
It's like a legal game of chess. So, what if the other side isn't playing fair during discovery? Let's say they just refuse to answer your questions or they try to hide evidence. What can you do then?
That's when you need to understand the options you have. The handbook talks about filing a motion to compel, which is basically asking the judge to step in and make them cooperate.
So, you've got the judge as a referee, ensuring everyone follows the rules.
Exactly. But even with a referee, you need to come prepared. The handbook explains that you need to clearly demonstrate why you're asking for this information, why it's relevant to the case, and why your requests are reasonable.
It's fascinating how these procedural details can have such a huge impact on a case.
Absolutely. It's like building a house. If you have a weak foundation, the whole thing can collapse.
So we've navigated discovery, we've built a solid case. What's next? It's showtime, right?
Right. And when it comes to actually presenting your case, the handbook talks about two main paths: a trial by jury, where it's your peers who decide the outcome, or a bench trial, where the judge makes the final call.
That's a big decision. How do you know which one is the right choice for your particular situation?
It really depends on your case. The handbook does a great job of helping you weigh the pros and cons. Like, let's say your case hinges on a really specific point of law, a technicality. In that case, a bench trial, where you're presenting your arguments directly to the judge, might be your best bet.
So you're choosing the battleground that gives you the tactical advantage.
Exactly. And once you are in that courtroom, whether it's a jury trial or a bench trial, the handbook emphasizes the importance of storytelling.
Storytelling. I thought we were talking about law, not writing a novel.
Think about it. You're trying to convince a judge or a group of jurors, complete strangers, to see your side of things.
Hmm.
You have to present your case in a way that's clear, that's engaging, and, yeah, even emotionally compelling.
So it's about connecting with people on a human level, not just bombarding them with facts and figures.
Exactly. The handbook even talks about using demonstrative evidence, things like charts and diagrams, to really bring your case to life.
That makes a lot of sense. A picture is worth 1,000 words, especially if you're dealing with something complex like a financial transaction or a confusing timeline of events.
Right. And all of this, the storytelling, the evidence, it's all building towards those key moments in a trial. Your opening statement, presenting your evidence, questioning witnesses. The handbook breaks down each of these elements and gives practical tips on how to handle them effectively.
It's like you're conducting an orchestra. Every element needs to work together to create this winning symphony.
I like that analogy. And, even with the best performance, sometimes things don't go your way, and that's where the handbook section on appeals comes in.
Oh, so it's not necessarily game over even if you lose the first time around.
Not at all. The handbook walks you through the appeals process, how to file an appeal, what to expect from the higher court. It even talks about something called preserving your arguments during the trial.
Preserving your arguments, what does that even mean?
Basically, it means making sure that if you disagree with a ruling by the judge during the trial, you make your objection clear and official. That way you create a record, and you can use that if you decide to file an appeal.
So you're already thinking ahead to a possible appeal even while you're still in the middle of the original trial.
Precisely. You're thinking several steps ahead. It's all about protecting your rights at every single stage. And this handbook gives you a roadmap for doing just that.
That's incredibly helpful. It takes away some of the mystery, the fear of the unknown that surrounds the legal process, wouldn't you say?
Absolutely. It all comes back to that idea of empowerment we were talking about earlier. This handbook wants you to understand that even if you aren't a lawyer, you have the right to understand the law, to fight for your rights, and to navigate the legal system effectively.
Like you said, it's about knowing the rules of the game. This handbook gives you the tools and the knowledge to become a more confident and effective player in the legal arena.
Exactly. Speaking of tools and knowledge, there's one concept from the handbook I wanted to unpack. Have you ever heard of ultra vires actions?
Ultra vires. That sounds like something out of Harry Potter, honestly. Break it down for us.
It sounds way more complicated than it really is.
Yeah.
Basically, it means that someone in a position of power, like a government official or a company,
Mm-hmm.
is acting outside their legal authority. They're doing something they're not supposed to do.
Okay, I think I get it. But how could a pro se litigant use that to their advantage? Can you give us a real-life example?
Sure, imagine you're in a situation where you're trying to expand your business, but there's this zoning regulation that's preventing you from doing so. You think it's unfair. So you do some digging and you discover that the city council didn't follow the proper procedures when they put that regulation in place. That could be an ultra vires action, which means you might have grounds to challenge the regulation in court.
So you're using their own rule breaking against them.
Exactly. The handbook gives examples of how to research this kind of thing and how to build a case around it. It's about understanding the limits of power and knowing when someone has crossed the line.
That is empowering. So we've talked about research, about legal arguments, but what about the documents we need to actually present in court? The handbook spends some time on affidavits, which seem like pretty important pieces of evidence.
Absolutely. An affidavit is simply a written statement that someone makes under oath. That means it carries legal weight. It's a way to get someone's testimony, their version of events, down on paper and signed under oath.
So let's say I witnessed a car accident and I need to provide an account of what I saw. I could do that through an affidavit.
Exactly. And that affidavit, because it's a sworn statement, could be used as evidence in court, even if you're not physically present.
That's really helpful, especially if your witnesses are far away or unable to travel to court. But how do you make sure an affidavit is strong and convincing?
Again, this is where the handbook's guidance is invaluable. It stresses how important it is to be clear, to be accurate, and to stick to the facts. You want to avoid hearsay, which is basically just repeating things that other people have told you.
Stick to the facts, no gossip allowed, got it. But sometimes you need more than just words on paper, right? What about other types of evidence?
Absolutely. The handbook breaks down the different categories of evidence, and it's not always what you might think. You've got direct evidence, which is like eyewitness accounts. And then you've got circumstantial evidence, which is more about drawing conclusions based on the evidence that you have.
Okay, give me an example of circumstantial evidence, because I feel like that one always trips people up.
Let's say you're dealing with a hit and run. There's no one who actually saw the impact. But you have security footage that shows the defendant's car speeding away from the scene just moments after the accident. That's circumstantial evidence. It's not a direct observation of the crime, but it strongly suggests that the defendant was involved.
So you're building your case piece by piece, even if you don't have that one smoking gun.
Exactly. And the handbook also talks about a category of evidence that I find fascinating: demonstrative evidence.
Okay, I'll bite. What's demonstrative evidence?
Think of it like visual aids for your case.
Yeah.
Charts, graphs, diagrams, even photos and videos. Anything that can help a judge or jury better understand the evidence that you're presenting.
So instead of just trying to explain a complex financial transaction with words, you could create a chart that visually shows where all the money went. It'd be much easier to understand.
Exactly. The handbook gives specific examples of how to use demonstrative evidence effectively. You're making your case more tangible, more relatable, and ultimately more persuasive.
It's about bringing your case to life, right? Instead of just throwing a bunch of facts and figures at the judge or jury, you're trying to create a narrative, a story they can connect with.
Precisely. And when it comes to engaging with the judge and jury, the handbook emphasizes a really crucial but often overlooked aspect of pro se litigation: courtroom conduct.
Okay, so this isn't like showing up in your pajamas and hoping for the best. There are rules, right?
Absolutely. The handbook really stresses that courtroom etiquette matters. You need to show respect for the judge, the jury, and the whole legal process itself.
So what does that look like practically? Give us the do's and don'ts of proper courtroom behavior.
Well, first impressions matter, so dress appropriately. Think business attire. You want to project this image of professionalism and respect. Address the judge as Your Honor. Stand when you're speaking and never interrupt anyone else.
So basically, good manners, but amplified for the courtroom.
You got it. And the handbook does give some very specific examples of courtroom no-nos. Arguing with the judge, rolling your eyes, making sarcastic comments. Those are big ones to avoid.
It sounds like the key is to stay calm and collected, even if things get a little heated.
You got it. Remember, the judge and jury are watching you, and how you present yourself can have a big impact on how they view you and your case.
It's not just what you say, it's how you say it and how you carry yourself in that environment.
Precisely. The handbook really emphasizes that courtroom conduct is not just a side note. It's a fundamental part of being a successful pro se litigant.
It really is like being on stage, isn't it? The courtroom becomes your stage, and you have to project that confidence, even if you're feeling butterflies in your stomach.
Exactly. And like any good performer, you need to know your lines. That's where all that legal research we talked about really comes into play.
So even with perfect courtroom etiquette, you still need to know the law inside and out.
Absolutely. The handbook encourages you to really get to know the ins and outs of the laws and precedents that apply to your case. It even shows you how to use legal databases and online resources effectively, so you're not just wandering aimlessly in a sea of legal jargon.
It's like having that legal GPS guiding you straight to the information you need. What happens if you find conflicting information, though? The law isn't always crystal clear, is it?
That's when things get really interesting. And that's where having this handbook as your guide is so crucial. It helps you analyze those legal precedents, figure out how your case is different from others, and make a strong argument for your interpretation of the law.
So it's about more than just finding the law, it's understanding how to use it to your advantage, right?
You got it. The handbook even provides examples of how to present your research to the judge in a clear, persuasive manner.
It's like piecing together a puzzle, using all those precedents and legal arguments as your pieces.
I like that analogy. And speaking of putting things together, we can't forget about actually drafting those legal documents. That whole process can feel like a whole other challenge in itself.
It's true. It's not like writing a casual email. You need to use that specific legal language and follow the right formatting. It can feel overwhelming.
Definitely. And that's where a lot of pro se litigants stumble. But the handbook breaks down the process into manageable steps. It gives you templates, examples for all different types of documents, from complaints and motions to those sworn statements we talked about, the affidavits.
So you've got a legal writing coach right there in your hands.
Exactly. And one thing it stresses over and over again is the importance of clarity and conciseness. Judges really appreciate documents that are well organized and easy to understand.
So save the legal jargon and get to the point.
Precisely. Now remember, all this prep work we've been talking about, the research, the document drafting, it all leads up to that main event, the trial. And when it comes to trial strategy and tactics, this handbook does not disappoint.
All right, give us a sneak peek. What are some key things that someone who's about to go head-to-head with another party in court should keep in mind?
Well, first and foremost, the handbook emphasizes strategic thinking. Don't just react to whatever the other side throws at you. Have a game plan.
So, like a game of chess, you've got to be thinking several moves ahead.
You got it. The handbook talks about anticipating your opponent's arguments, being ready with counter-arguments, and even using those procedural rules to your advantage.
Using the rules to your advantage. That sounds a little sneaky.
Not sneaky, strategic. Let's say the other side tries to introduce evidence that you know shouldn't be allowed, like hearsay. If you know the rules of evidence, you can object effectively, maybe even get that evidence thrown out. That could completely change the course of your case.
So it's like that saying, know your enemy and know yourself, and you need not fear the result of 100 battles.
Exactly. And the handbook really digs into those specific trial procedures, like how to present your evidence properly, how to cross-examine witnesses, even the best ways to raise objections.
Speaking of objections, that's one area I think a lot of people feel intimidated by. They're not sure how to do it right or when it's appropriate. What kind of guidance does the handbook offer on that front?
That's actually one of my favorite parts of the handbook. It lays out all the different types of objections you can make, things like relevance, hearsay, leading questions, and gives really clear examples of how and when to raise those objections in court.
So you've basically got a toolkit of objections at your fingertips, ready to go at a moment's notice.
Exactly. It even tells you how to phrase your objections politely but firmly, which is so important for maintaining your credibility with the judge.
It's all about finding that balance, isn't it? Being assertive but also respectful, knowing the rules but also knowing how to use them strategically.
You nailed it. And, even when you've prepared your heart out, the handbook acknowledges that things don't always go as planned. Emotions run high, unexpected things happen, and it's easy to get flustered.
So what's the best way to stay calm, cool, and collected in those intense courtroom moments?
The handbook actually suggests practicing mindfulness techniques, things like deep breathing or taking a moment to just gather your thoughts before responding. It also stresses the importance of self-care throughout the entire legal process.
Right, because it is a marathon, not a sprint. You have to take care of yourself, both mentally and emotionally.
Exactly. And remember, even if you don't get the outcome you were hoping for, the handbook's got that entire section on appeals, so it walks you through your options if you decide to take that next step.
It's like having a guide for every step of the way, from preparing to file your initial paperwork all the way through to a potential appeal. It really is incredible how comprehensive this resource is.
It is, and it all comes back to that idea we keep talking about, empowerment. This handbook really wants to empower people with knowledge, with strategic thinking, with the confidence to navigate the legal system, even if they're doing it on their own.
It all circles back to that idea that knowledge is power. And when it comes to something as complex as the law, the more you know, the better equipped you are to fight for your rights. And this handbook, it really does give you the tools and insights you need to level the playing field.
Couldn't have said it better myself.
This has been an incredible discussion. I feel like we've really uncovered some important strategies and insights today, wouldn't you say?
Absolutely. And for anyone listening out there, if you ever find yourself facing a legal challenge, remember, you don't have to go through it alone. Do your research, seek out resources, and never underestimate your own ability to advocate for yourself.
So well said. And one last thought, remember that provocative question the handbook poses. How can you use your knowledge of those procedural rules, those often overlooked details, to potentially turn the tables and use your opponent's missteps to your advantage?
It's something to keep in mind for sure.
It is. This has been an amazing deep dive. Thank you so much for joining me today.
It's been a pleasure.